Okay, it looks like people are settled in. So welcome everyone to the first of what should be several day in the life events. This is kind of a series that we do at the Center for Business Law. My name is Camden Hutchison. I am the director of the Center for Business Law, and it is my great pleasure to introduce Aneez Devji and Jennifer Wong from Buell Sutton LLP, both real estate lawyers. So I'm just going to give them a very brief introduction, and then they can say more about themselves if they'd like, or just go ahead and get started with their presentation. So Aneez is a partner at RBS in the real estate group. He is also the managing partner of the firm's Vancouver office. He has over a decade of experience advising on significant commercial real estate matters for private developers and landowners, including many locally and family-owned investment firms, banks, and institutional clients. Jennifer Wong is an associate at RBS, also working in the real estate group, with a focus on secured financing transactions and commercial leasing matters. She also serves as a director for Lawyers for Climate Justice, as a volunteer lawyer with Access Pro Bono, and as a member of RBS's Equity, Diversity, and Inclusion Committee. And they are going to be speaking today about their real estate practice and about real estate practice in general, which is a very interesting and important area of law, particularly here in Vancouver. And it's also an area of law that I do not know very much about. So I'm looking forward to learning more about the life of a real estate lawyer. So without further ado, please go ahead.
Thanks, everyone. I'm Jen. I am a real estate associate, as Dr. Hutchinson mentioned.
Hi, sorry, I missed that. I was trying to get the mic.
Sorry, smooth start.
Yes.
Who here is in 1L out of curiosity? Oh, okay, lots of you. Okay, 2L? 3L? Okay, wow, lots of 1L students. Glad to see the enthusiasm and interest in real estate practice. So today our presentation's about structuring and negotiating real estate transactions. It's giving you a little taste about what our day-to-day practice is like, along with some practice considerations for you guys to listen to, and feel free to jump in or raise your hand with any questions you might have throughout the presentation, as it's relatively informal. So a quick overview of what we're going to be talking about today. As mentioned, we're going to go over some considerations in real estate practice, a brief overview of the various practice areas, since you guys might not have familiarity with these. And then we'll provide some insights and advice with regards to our practice areas from both the partner and associate perspective. So I thought it'd be helpful to go over a brief snapshot of what our day-to-day practice areas are like when we walk into the office. So typically when I walk into the office, I have a pretty good idea of the immediate tasks I need to handle, you know, the ones that were sent to you at 5:30 p.m. the night before. And so you're like, okay, now these are priorities, or things I flagged in my inbox for me to handle that are longer term tasks. Generally, when a client reaches out to us, we have a pretty good sense of how urgent a task is. It's always helpful to ask, like, if you're tied up with something immediately, to say, you know, is it okay if I get back to you next week? Or like, what's the urgency level on this, to clarify? And along with actually working on client files, we have to juggle any meetings or calls that are set up with clients with regards to, you know, executing closing documents, or, you know, check-ins about various files or status updates. So I tend to do more like legal drafting and reviewing things than actually attending meetings and calls, but I know that can change from seniority levels.
Yeah, so the flip side to that is you wake up at whatever time, you roll out of bed, it's a terrible habit, but you look at your phone, right? And it's sometimes to check what happened in the sporting event, but it's usually how many people in Toronto emailed me overnight or at 5 a.m. this morning saying, why aren't you awake and doing something? So you start with looking at your phone and you say, all right, the day is off to a rocky start. That's okay. I still haven't had coffee. It's going to get better from here. It's probably a little unfair. Most days are not that bad, but it is kind of you unfortunately, the fact that you have a phone that connects to your work email means you're always kind of in the office. The remote work situation also really made the situation worse, I think, because you're always accessible, always available. And so you check your phone. All right, my day started. You caffeinate up, you eat, you do whatever you can. If you can fit in some exercise, great. And then you think to yourself, all right, I'm going to get these 3 things done today. They're going to take an hour each. I've got all day to finish them. And you get to your desk, and somehow it's the end of the day and you haven't touched any of those 3 things. And you don't know how, why, what happened. But that's because your daily plans always get sidetracked. You're always getting sidetracked. And it's because you get a call from somebody who has something that's more urgent. You get brought in on something that's more urgent. So it's really a case of managing your priorities, and it's managing your time. It's at the end of the day, it's important for you to create your own boundaries. And this isn't a talk about managing boundaries, but it's a talk about understanding that there's no real predictability most days in the office. And so you'll end up spending a lot of time on a call with a client talking through various ideas. And it's not so much I'm sitting here drafting a contract or I'm reviewing a lease. There is a large problem. The client wants to talk to somebody about it and wants you to start pointing out areas they need to investigate further, or hey, they want to know that there's no red flag from your perspective. And I find that quite a nice part of the practice. I don't want to just sit and draft contracts all day. I want to engage with clients, especially in real estate. You want to feel like you're a partner in their business. So when we say a snapshot of the day, it often means also me walking down to Jen's office and saying, by the way, I had these 3 things I thought I would do today and I haven't touched them. Can you please help? And can you please help me get them done? And of course, Jen does. So that's what makes it work so well.
Well, I'd like to jump in and say that's part of the client management piece. When you get an email saying, can you help with this? It's always nice just to send an email saying, okay, got your message. Like we're working on it and we'll get back to you if there's going to be a bit of a delay. Also, I tend to find that to-do lists and like calendar reminders and Outlook are really good ways to help keep track of what we need to do from day to day, as well as relevant deadlines. So that's something I use a lot. From kind of a broad perspective, I think a lot of the growth I've done as an associate is knowing what I don't know, if that makes any sense. On a file, you're often thrown in not from the beginning stages of the client reaching out, but once somebody has gotten some background information from the client and spoken to them already. So then I would help assist to close the file or prepare the relevant documents. So it's always good to check with your team members about what information they might have about a file before you start working, because there might be other factors to consider you might not be aware of before you start to draft documents or take a look at a file. Also, with regards to real estate, there's sometimes due diligence that is best to be done at the outset of a file, so you know a little bit about the property, what's registered on title, relevant zoning considerations, and those types of charges. And with respect to areas of law, it's also helpful to know when you're a little bit out of your depth. To highlight a recent example that popped up actually today, we're working with a client with regards to a sale of a piece of real estate. And they were looking for us to review a termination agreement with respect to an employee who worked at the property. And I asked Aneez, I was like, hey, do we review these, or should this go to someone who actually practices employment law? Because I'm not super familiar with that area of law. And so he was like, yes, you should refer it to someone else in the employment law group. And I was like, oh, great. So now I know when to spot these when these are a little bit unfamiliar to me. And that's part of the benefit of practicing at a firm where we don't just practice real estate. We have other practitioners that focus on other areas of law. So that's something I really like about our firm.
Yeah, I think that's a good point. I don't know what TV shows are still popular. Like it might, when I was here a few years ago, I like to think, Suits was one of the big shows. And if anyone's watched it, every week there is a new area of law that they seem to be able to practice in and become experts in. That is just so unlike anything you're going to experience in your practice. It's nice to think that, hey, one week I'm doing a criminal case, and the next week I'm going to be doing some civil matter. It's just not that way. And on the solicitor side, there is a lot of value in knowing your area of law quite well and acknowledging that there are areas of law that you're not going to have that expertise in. And yeah, it's unfortunate if your friends call you and say, "Can you give me some advice on this employment issue?" You just can't, and you need to be able to acknowledge that you can't. So in this situation, our employment lawyer who we'd consulted came back with some really relevant comments that we would never have been able to put together unless we spent, years practicing in the area. So acknowledging what you know and what you may not know is quite important.
Yeah. And that plays into my next couple of points, which were it's important to ask questions if you're not sure about the scope of something or, what the relevant points are and when to call in the cavalry. So when is help needed on a file? Some other relevant factors to a real estate practice are not super sexy, but economic considerations. I know a lot of lawyers like to be busy, but there's often, a threshold to how busy you want to be because at a certain point, your clients will start to be like, "Hey, like you told me you were gonna get this done for me. Where is it?" And I think that's obviously a point at which your practice management skills or, just the threshold of work is too much for you to manage. And so that's where, delegation comes into play. I think it's a particularly important skill for a real estate lawyer, provided that we often work closely with paralegals and other lawyers who practice in our area or even outside of our area to help get a file across the finish line. And so that also plays into the team approach that our firm has, I think, a lot of the time with regards to working to paralegals and legal assistants and other staff at our firm to get things done. And with regards to precedents and templates, these can help you really streamline your practice. If you have gotten familiar with certain files and certain clients that like to do things a certain way or use certain precedents, you'll be able to turn out documents at a much faster pace. The other side of this is that you need to be aware of changing developments in the law that can require updates to precedents, so you can't get too stagnant with using these. But they can be a huge time saver and really help your team be efficient in your practice. Also, something to keep in mind as an associate is that most firms have a billable target. So this is a pretty good way to keep track of your productivity and whether you're meeting those targets. I mean, if you're short by a magnitude of kind of a couple hundred hours, well, that's a pretty serious sign that you're behind target. But if you're on target or above it, well, that's a sign also that you are on track financially with your billings and amount of time you need to invest into your practice.
Yeah, I don't, for those of you who are kind of newer to law school, I don't know how many times you've heard of the billable target or billable hour, but yeah, welcome to the next, forever of your life. If you're going to be in private practice, it's a measure that I'm not sure it's going to last forever, but it is for an extended period of time going to be there. A measure to see how much you're working. There's not I check in at 9 o'clock or 8 o'clock in the morning and I check out at 6 p.m. and I put my hours in. That's how it works. You're managed based on how many hours you're recording to files, how many hours you're billing, and that's just one of the economic considerations of, is this a profitable exercise? Because at the end of the day, that is in private practice one of the many considerations of your files. So I think managing too busy is an important part for how you handle being able to have a sustainable practice. But I also, at the end of the day, acknowledging that you're gonna be competing. It's kind of that delicate balance between finding the right balance of hours for you and also ensuring that it's consistent with the expectations of the firm and the environment you're working in. Yes, go ahead.
Yeah, I was just wondering if I could interject something. So, just kind of speaking from my own personal experience. So I was an M&A lawyer. I was not a real estate lawyer. So different areas of law, but at the end of the day, you're doing deals, right? So it's probably in broad strokes, the practices are comparable. And something you said just really resounded with me, and so I wanted to emphasize it, just because it's very consistent with my own personal experience. And depending on your circumstance as a young associate, it is really important that you strike the right balance, and that's going to depend on where you're working. But you don't want to be, you want to be busy, but you don't want to be too busy. Like you don't want to take on more than you can handle. And so like you can find yourself in different situations at different firms. Like if you don't have enough hours, you're struggling to meet your billable target, that's bad. But if you're at a firm that's really busy and there's, there's tons of work to go around, like everybody's going full tilt, you have to be really careful in kind of managing your, how much you're working. And I don't even mean from a lifestyle standpoint. I just mean from the standpoint of you don't want to stretch yourself too thin and end up disappointing people. So I was at a firm that was very, very busy. Like everybody was just like billing like crazy. And it was a really important skill. You had to learn how to say no to partners, and you had to learn how to say no, to clients potentially. So like partners would constantly be like, hey, can you get on this deal? Can you get on this deal? And they don't want to hear no, right? Like they don't want you to tell them no, but you really have to learn how to kind of assert yourself, because if you don't, you're going to drop the ball and it's going to be worse for you. It's going to be worse for everyone else. And I saw firsthand, like, other associates who would just kind of like thought they had to say yes to everything, and they would get steamrolled, and it would actually end up being worse for them. So that's like a really kind of important part of, I guess, managing your practice as a young lawyer in particular.
Yeah, thanks for adding that. I think that's important. And I'm a little worried we're just going to go in tangents, but I think this is supposed to be informal. So if you bear with us, we'll try to give a lot of this is unsolicited advice, but we may as well share it because take away a few of these things and hopefully they help. And Jen's going to say, Aneez, you totally have it wrong. The associate view is very different. But in terms of managing your workflow, as a younger lawyer, your clients are not actually people outside of your firm. In most cases, your clients are the lawyers who are giving you the work. So when Jen was saying, the file comes in and there might be some background, that's because the file is typically coming in from a senior lawyer who's got the client relationship. The idea of saying no, if an associate said no, I'm not helping you, and just kind of that was the end of the conversation, I gotta tell you, I'd be pretty frustrated with that response. And so it's not as easy as saying no. But if they said yes and dropped the ball, didn't do the work when they said they would, I'd be probably a little more mad. So it's finding the right way of addressing it. Each lawyer is going to be unique. It's managing your client, managing the people you're with. And so I said, Jen, I really need your help on this big file. And she said, great. I'm also helping, other colleague with this other really big file. So they're both going to have to, how do you think we should do this? All of a sudden now I'm thinking it's become something we're going to solve together. And it's not a no, but it was very clearly, I can't do it. How do you want to fix this? So just something to tuck away as manage your client and find a way to delicately get yourself out of that position, because you will be in that position. Rest assured that is coming. So
Yeah. I just wanted to say, like, it's a matter of communication, right? Like with your client, with your team members, what you've already got on your plate and that sort of thing. So it's not too complicated in theory. Turning to future work versus present work. I personally like to leave a little bit of space in my schedule for files that are coming down the pipeline that I might not necessarily be aware of. Our staff does a really good job of trying to let us know that new files have been opened and that they're going to be coming my way. But there's always last minute requests from clients and that sort of thing. So when I walk into the office, I don't want my whole 9 to 5 to be delegated towards various files. I want to leave a little bit of wiggle room, because otherwise I think you're going to end up scrambling and dropping the ball potentially. Also keep in mind that in an ideal client situation, your current clients are going to be repeat shoppers. So if you have a really good relationship with a client and they do a lot of leasing work, keep in mind that they'll probably come back to you with other leases down the line that they may have. So that's another stream of work that can come your way besides senior lawyers delegating it to you. One thing to keep in mind, these might be a little too nitty-gritty, but sometimes your work can be written down. If you've invested a lot of time in a file, it can be frustrating to see your time written down, meaning that the partner has decided that they're not going to bill the client for the whole amount of work you did, but it's a necessary part of the learning process in most cases. While you may be inefficient at your first couple of files, you learn how they work and you become more efficient as time goes on, is at least the goal. So don't be too disheartened by those in your first couple of years of practice. With respect to closings and deadlines, as previously mentioned, it's really important to keep track of your relevant deadlines, whether they're internal deadlines. Aneez says to me, can you get this memo to me by end of day Monday? Or a client says, this is a drop dead date for us to file this document at the land title office. So just keep in mind soft deadlines, which can sometimes be negotiated, and hard deadlines that are absolute drop dead dates. Okay, so now we're turning to a little bit of overview about our actual practice areas. So purchases are part of a transactional real estate practice, which basically means buying and selling real estate. And so the first part of a purchase is where we step in is typically looking at a contract, whether it's a draft contract that our client has yet to sign, or a fully signed contract because the client already has signed it and the other side has signed it. And so everyone is legally bound to uphold their obligations under the contract. So the initial inquiry I always have for a contract, which may sound silly, but is what is actually being purchased? Is it residential real estate? Is it commercial real estate? Because the relevant considerations and types of searches and due diligence work we do for those types of parcels differ. So typically I first look at the title search, which is the document that sets out all of the non-financial charges on title, such as easements, covenants, and those sorts of things, as well as any prior financing charges, such as any mortgages. You guys might not be super familiar with these yet, but I'm sure you'll get an overview from your property law professor. With regards to subject clauses, these are clauses in a contract that state that a contract is not legally binding necessarily until certain conditions are met. And if these conditions are not met, then the contract is not actually legally binding. The most common one in favor of a purchaser is the purchaser obtaining financing or mortgage that is satisfactory to them. So that's really common to see in residential contracts. So that's something to keep in mind because you need to keep track of what date the purchaser needs to be able to, the purchaser has to waive that condition by. So that plays into key dates. So as mentioned, being organized and knowing all the relevant dates for a deal is really important because otherwise your client can lose their rights under a contract to purchase a property because the contract is rendered void, or the other side might be able to sue your client for damages if they don't uphold their obligations under a contract. So the really common key dates to keep in mind for a purchase are when deposits have to be paid, when a closing date is, when the purchaser needs to remove their subject clauses, as well as what dates a party has to deliver due diligence materials. So you might be wondering who actually is involved in a purchase on the real estate team side. So it's really a team process, as mentioned on the slide. Like your client, you often have an instructing individual who represents like the corporation or a family buying a property. So there's usually one person that will send you emails that you get information from. There's also typically a paralegal who helps to prepare the relevant land title office documents as well as the other purchase documents involved for a deal. Usually clients will have a realtor. It's more uncommon not to have a realtor. So this person may know additional things about the property besides the client and may help facilitate even the preparation of the contract and addendums for a real estate, for a residential purchase. If your client is getting financing, there's usually a bank, or sometimes it's automated. It's not actually a person that sends you mortgage instructions to prepare financing documents. And then you'll also have to deal with the vendor's lawyer on the other side. It can also be a notary. So in dealing with all of these people, as previously mentioned, communication is really important. Keep everyone up to date on, any like changes to the deal, like your client wants to change the closing date, like there needs to be an amendment, you should let the realtor know. The vendor's lawyer will have to sign off on it because they'll have to advise their client on this. So it's really keeping everyone in the loop as much as possible. And something to keep in mind is that the purchaser's law firm prepares conveyance documents for both a purchaser and vendor. So if you're acting for a purchaser, you've doubled the amount of work, basically, than a vendor's lawyer.
Yeah, I think it's important to recognize that these transactions, they will become quite familiar with if you become a real estate lawyer. If we were to move it to a residential context, it becomes a bit of cookie cutter. You know, you kind of go through the process. You've got a ton of conveyances. We call them conveyances. You've got a ton every month, and you already know what's going to happen. You can predict how the file is going to go because, you know, typically there are only so many outcomes for these transactions. So 95% of them are smooth, and you know what's going to happen. For your client, though, and this is something important to remember, this is the single largest purchase possibly they're ever going to make in their life. And that's where there's a bit of uncertainty, where the client needs to have their hand held. The realtor who isn't used to doing these types of transactions is really focused on getting their commission, which is only payable when the transaction closes. Your lender may or may not have a unique requirement for about something that was discussed directly with your client. So the lender says, hey, they promised me that their parents would guarantee the loan. He said, well, no one's talked to us about this. We don't know about this. And it's complicated by the fact that in a residential context, in most cases, your role as buyer's lawyer is also to act on behalf of the bank. It's a permitted conflict, we'll call, and it is actually permitted. But in those situations, you're wearing a couple different hats, and you've got what you think is a relatively simple or straightforward transaction that can get quite complicated very quickly or very unexpectedly. So I think that's something to keep in mind. If you're in the commercial space, and that's where the parties are typically more sophisticated, the lenders have their own counsel, the brokers typically have a little more experience in this space. So it does become a little bit easier in a sense. There's more legal work, you charge more. So there's a whole different set of circumstances, factors to consider there. But just as Jen was saying, communication is key. Sometimes you have to know you're going to have to get to the realtor early so they don't blow everything off the rails and start saying that you're the worst lawyer they've ever dealt with, and you know they want to send your client to someone else. Sometimes it's the vendor's lawyer who has 100 files on the go and doesn't have time to pay attention to this particular issue, and you've got to get them, you got to grab them and focus them in on your deal so you can make sure that you're not stuck the night before closing stressing about what's happening. So a lot of it can be straightforward, but you spend most of your time on the few files that aren't, and those are the ones you remember. That's also part of how your experience goes.
Yeah, from my experience, purchases can be either the easiest file or the hardest file to deal with, depending on client dynamics, the property itself, or unexpected developments that can arise. So it's really hard to tell at the outset sometimes what type of file it's going to be. With respect to closing a purchase, this is the way it's supposed to go if everything goes smoothly. So everyone will sign the closing documents. They'll be sent to each other's side. So the purchaser will send it to the vendor's lawyer. The vendor will send it to the purchaser's lawyer. The purchaser, if they're getting financing, will receive the mortgage funds and get money from their client as well to close the deal. And so the purchaser will send all that money to the vendor's lawyer in satisfaction of the purchaser's obligation to pay the purchase price under the contract. Then the land title office documents will be registered. So typically this is a Form A transfer if title is being transferred. Then post searches will be done to make sure everything looks good on title and there's no sneaky surprise that's been slipped in after the Form A document has been registered. And then the funds are released to the vendor. And then as purchaser's lawyer, we like to report to our client because people will often be like, has it closed yet at like 9 a.m. And it's like, no, it hasn't closed yet. Nobody has done actually anything yet. So closings typically happen later in the day in my experience. On the flip side, sales are usually a bit more straightforward than purchases because you're not preparing the purchase documents. So your client has less obligations under the contract. Typically, it's, the seller makes certain representations and warranties like, oh, this property has not been used for the manufacture of illegal substances. that type of thing are quite common. Again, acting for a seller, you want to be aware of key dates because you want to be aware if you need to be following up with the purchaser for closing documents and when the closing actually is. And with respect to title searches for the property being sold, you just want to be aware of any prior mortgages that the seller needs to pay out upon closing, because you have to order the payout statement sometimes weeks in advance. With regards to closing the sale, your client will sign the conveyance documents if you've done your review of them and they look okay. As mentioned, for mortgages, you will order the payout statements. Often the paralegal does this, who's assisting you in the file. And you also need to carefully review the undertakings that a purchaser's lawyer will be placing on you. So the way I tend to describe undertakings are unbreakable lawyer promises. Aneez is actually our resident expert on undertakings. We'll be doing a presentation on them for Continuing Legal Education BC. But basically, you never want to be in breach of an undertaking ever, because you can get reported to the Law Society. And I'm pretty sure these show up on your record when people search you, and you can't erase them.
Yes.
Yeah. So yeah, never break an undertaking. Always be sure if you're accepting one that you are able to fulfill them. So you don't want to accept any vaguely worded undertakings from a purchaser, or undertakings to pay out anything that doesn't have a firm dollar figure and you are sure you have that much money available to you to deal with that charge.
Yeah, just to kind of bring everyone back in for a second, who here has been involved either through family or on their own through a purchase or a sale of any sort of property? Yeah, that's good. That's at least a few hands up. So in terms of the transaction, if you were buying property, you're involved on the purchase side and the seller has financing, do you give consideration to how the money actually flows between the parties? Because in theory, the buyer needs to pay all of the money, the purchase price, to the seller, and the seller actually needs that money to pay off their financing. The seller's not coming up with their own money. Was that something that was explained, or was this something that we just kind of accepted as this will get sorted out eventually? Perfect. The kind of answers I was hoping for. So I think the idea of the undertakings is the unique way for lawyers and notaries to close transactions. You might hear terms like it's in escrow, things are happening in escrow. In practice, for a lot of simple residential deals, and especially deals in BC, the idea is that you use undertakings to address these very concerns. The seller can't discharge their mortgage. They can't pay out the existing bank loan. Their existing bank has a mortgage over this property until they get the purchase price. The buyer doesn't want to give the purchase price until they know that the seller's bank is going to release their mortgage. So how do you address that? Through undertakings. Buyer's lawyer gives the money to the seller's lawyer on their undertaking, and then it gets a little more prescribed to get a payout statement and to pay the amount required by the payout statement, and then to make efforts to obtain the discharge of the mortgage. So if you buy property, you actually aren't going to get a clean title search possibly for 60 days, because that's typically the period of time you're given to arrange for a discharge of the existing seller's mortgage. So if you ever want to have someone panic, ask them to look at a title search of the property they bought 5-6 days after closing, when they still won't show up as the registered owner because the land title office is still processing the transfer, and there will be a mortgage in favor of the seller's bank still. So keep that in mind if you're doing a transaction. Again, it'll become normal for you, but it's not necessarily normal for the buyers and the sellers you're acting for. And that's why we use undertakings. That's how you give comfort to your client. Yeah, go ahead.
Hello. Okay. Oh, the zoom in thing. Okay. I just wanted to ask, so why did you guys sort of choose to be solicitors, if I may ask? And then also I heard somewhere that somebody said that real estate can be really good because it can be really structured, but that sometimes it can be really difficult to plan your time just because of the craziness of what goes into a closing. So especially during closing times, how do you sort of work with work-life balance and especially family? And especially since if you're doing something near Toronto where the time difference is crazy. Yeah.
Do you want to speak about how you got into real estate?
Sure. I liked the team-based aspect of real estate personally. Like it felt nice to work together with paralegals and like the other side, whether it's like purchasers, vendors, counsel, to work towards a common goal and work together towards a mutually beneficial solution for everyone. I personally knew that I never wanted to go into litigation. I hate conflict, and so that was something I was aware of even in law school, that that was not an option for me. So made the choice easy for a solicitor practice.
Yeah. My answer is not as nice as Jen's, but I can give you the truthful answer, and then I'll give you the follow up, which I tell people. So the truth is, I really, really wanted employment, and RBS had an opening, and the real estate group they needed a junior, and they had a strong real estate group, and they had a strong set of clients, and I thought, hey, employment and this seemed to go together, and that was great. It's not necessarily that complicated. It did help that I got along well with the real estate lawyers at the time, and unfortunately within a few years, a couple of them retired, so it was a really short window. But at that time, I thought I live in Vancouver. Real estate's a strong market. This is pre kind of the craziness as well, the kind of 2013 run up. So it wasn't like I knew this was going to be a great for transaction volume, but I knew I wanted employment. I was really afraid of not having it. And so that pushed me to an area where I thought I could find it. And I thought the skills would be transferable if ever I wanted to leave private practice. You wake up one day and you're still practicing, and it's been many years later. So that's the kind of how I ended up in real estate. I did grow to love it a lot more than I did at the beginning. The part about managing your days, I've got two young kids, and it is a challenge. It's something you're always going to be dealing with in terms of, I've got some days where you're thinking, I got a closing, how do I manage this? I think staying organized, staying on top of your files, a lot of my practice is very much, I worked to deadlines in law school and undergrad. I was like the king of getting everything done the night before an exam, a paper's due. Like I was the most efficient. Like I think if you could just put that like 8-hour stretch and stretch it out to like, an entire semester, I could have been really good in law school. I could have had really good grades. But, the last 8 hours, I was very efficient. And so I had to manage that a little more. I had to work on that. The one thing I will say, and law firms will tell you that's not entirely true, is there's a lot of flexibility in your own scheduling as well. You'll have client meetings. There's an expectation you're in the office, but post-pandemic, there's a lot of firms that do still allow working from home for a period of time or some days a week. So if something needs to get done, so say you've got a lease you got to look at, it can be done at 10 in the morning or it can be done at 10 at night. And sometimes you'll say, I want to be home for dinner with my kids. I will leave work early and I will work late if I need to make up the time. So you're not stuck at a desk in the office all the time. It's not always going to be that way, but there are times you can make that change. And I think that's really nice flexibility. Like I wanted to be home Monday morning because I wanted to do something with my kids. And so I just went to work late and I showed up at 10. And you're kind of sheepish a little bit because you're like, everyone's been working for a while and I'm kind of just strolling in now. But that's okay because I made up the time that I needed, or I didn't have as much to do. So I was okay to kind of take a couple hours off, and you don't have to dock that. There's no tracking of that. That's just your billable hours. You didn't have anything until 10 that morning. So that's, I think, part of how you manage that.
I also think practice is more of a marathon than a sprint. Like if you're going full tilt, like for more than I think a month or two, you're going to get burned out, like in reality. For a solicitor-based practice, it's really common to have a lot of closings at the end of a month. So I tend to plan my social calendar around that. Like I don't like to make plans around the end of the month because I know specifically that I will have a large number of closings unless there's a slow month or like something else happens. But that's the exception rather than the norm. So that's something that I like to keep in mind.
So does anyone want to build on that? I mean, this is just a good time to ask kind of any follow-ups to that particular, almost a question, but okay. If not, we'll keep going through the exciting part of this side.
So this is commercial lending. So this is a pretty large area of my practice, lending law. So our firm acts for a number of banks and financial institutions to give loans to businesses as well as to individuals secured by commercial property. So typically when we're instructed, what this involves is taking a look at the commitment letter that usually the borrower has already signed with the bank or financial institution to see what form of security is being entered into. So what security is typically a mortgage. There can be a general security agreement, which secures all personal property of a borrower. And then there can be guarantees from individuals or other companies, or kind of the three most basic ones. So we usually have to take a look at the solicitor instructions as well. Not usually, always. We take a look at the solicitor instructions as well to prepare the security documents, because there could be more nuanced conditions that our client or the lender wants us to review the borrower's documentation for before they'll advance the loan. So in order to make sure our client is really informed about who they're giving money to, we very carefully review the due diligence searches that usually the paralegal pulls to make sure that we're placing the borrower's lawyers on the relevant undertakings to make sure that our client is being secured properly, as well as making sure any pre-funding conditions are met that are required by our client. And then finally, typically the lending paralegal will prepare the first draft of the security documents, and the borrower's lawyer may have comments or request revisions. And so we need to assess those and seek instructions from our client, but also advise them of the risks of accepting any potential revisions to security documents. And then just to give you a very brief overview of what a lending file is like when it closes, the borrower will return signed security documents to the lender's lawyer. The lender's lawyer will register security and take a look at the post searches, which are usually quite similar to the due diligence searches performed. And then the lender's lawyer will release funds to the borrower's lawyer. And there may be undertakings involved if there are any financing conditions that need to be met. Next up is commercial leasing. I also practice a lot of commercial leasing, and Aneez has a lot of commercial leasing clients. The reason why nobody does residential leasing is because I think there's not very much money involved, and everything is governed by the Residential Tenancy Board, which is meant to be accessible to individuals. So usually the thought is that nobody will need a lawyer to advocate for them at the Residential Tenancy Board. So that's an access to justice consideration that goes into that. So what we practice is commercial leasing. So, office spaces, malls, retail spaces, restaurants, warehouses even. Those are the types of spaces that we do commercial leasing for. So commercial leasing there's a lot of considerations that need to be considered when you're drafting or reviewing a lease. Typically, commercial landlords have a precedent form of lease they like to use, so the same one they use for every tenant, and then the tenant has to negotiate changes to that set form if they want to. So you need to confirm, obviously, whether you're acting for a landlord or tenant, because that will inform the scope of your review and what type of comments and what your client's risk tolerance is. So you also need to confirm whether anyone is giving an indemnity to the lease. So this means that they'll be personally responsible for any breaches of the lease by the tenant. Whether you're landlord or tenant, I think it's necessary to do due diligence searches on both the relevant property being leased as well as the entity that is leasing. If it's a company, you can do a corporate search and make sure that they actually exist or are not going to be imminently dissolved for failing to file corporate records, because that means there's no entity to sue, basically, if there's a breach of the lease. One thing that you'll need to check with your client is the scope of review, as mentioned. So this is a bit of a communication piece. Some clients will just want you to go through a lease and make sure there's no drop dead clauses, anything that's like incredibly favorable to the other party that would not be typical in commercial leases. And sometimes they're very sensitive to particular issues. So you need to confirm with them what they'd like you to do. And that also plays into my last point, which is risk tolerance.
Yeah, if I can add on the leasing side. So just to give you some background on this, and this may be something everyone knows, it may not be, so I'll just go through it quickly and then we can discuss it, is the idea of the landlord's lease form. And so you look at an office building and you look at it and say, all right, there's a garden in front of the building that's part of the property the landlord owns. The landlord gets a landscaper out there. The landscaper charges $1,000 a year. The landlord wants to charge that right back to the tenants. They want that to flow through, and you want to charge that to tenants. Having consistency in your leases allows you to have the same rights to charge back to your tenants. So that's an example of something that, some tenants may say, well, I have no benefit of this garden. I don't want to have to pay for it. This is something you should cover because I'm paying you my rent anyways. That includes having a nice garden. So very simple, but problematic issue because now it changes the accounting for the landlord. How do they charge tenants? Having that lease consistency is important. Get to a little more extreme example. You have an older building in a nice area, and especially in Vancouver, this has happened a lot. The landlord might have a demolition clause in all of their leases. A demolition clause means that if the landlord can do a 10-year term with a tenant, give them options to renew or options to extend, and the landlord can say, well, this building is no longer, there's a better economic approach for us. We can tear this building down, build something new, and make more money. That works for us. But we're stuck because we have all these leases we've agreed to. So we have all these tenants in the building. We're going to exercise the demolition clause. If all but one of your tenants have a demolition clause, we've got a problem because now there's one tenant who can hold your building hostage. So you're going to have to go and negotiate with them. And I have seen this. Those tenants figure out very quickly that they can hold you hostage, and they will charge you like an enormous amount of money because they'll say, why should I agree to an early termination of my lease? You agreed to lease it to me, I'm going to hold you to the term. So there's a lot of specific issues you're going to deal with in leasing as if you're acting for the landlord or the tenant, but there's some big picture things you need to be aware of. And I think that's why it's important when you have clients that you do the leasing for them on a site or in a building, you have to have that institutional knowledge, we like to describe, that the history. Why is there a demolition clause in this building? Why are we charging the landscaping in all of these leases that tenants don't seem to want to pay for? And there might be a very good reason. It might be because the landscaper actually charges $100,000 a year, or that the landscaper actually does 5 of the landlord's buildings. And so there's just an allocation of costs, and the landlord really doesn't like paying for landscaping. It could be as simple as the president of the company has a rule that they won't do it, and that's just decreed. And whether or not it's business savvy or legal, doesn't matter. Those are your standing instructions, and now you know for every lease you do on that building. So the leasing part can become quite challenging if you don't have any history with the client. And so there is a lot of value in having acted for a client for a number of years.
So next up is development files. Simply put, development files deal with the early construction of a property and selling the property in bulk, as well as selling the property before it's actually built. So there are very specific rules with regards to offering a property that is not yet built under the Real Estate Development Marketing Act. So
sorry, Jen, I'm just going to say these are commonly known as pre-sales. If anyone, you hear about pre-sales all the time and how everyone's flipping pre-sale contracts. This is pre-sales, but just the more legal terminology.
Yeah, so the very long document that a purchaser gets before they are offered the pre-sale unit to purchase is called a disclosure statement. Some of you may have heard this term. If you're familiar with securities law, this is kind of like a real estate prospectus. So it makes sure it discloses all relevant facts about the property and the upcoming development that a purchaser may want to know that is relevant to them making a decision as to whether to purchase the property or not. So this is just a brief walkthrough of the life of a development file. So typically, our firm gets involved preparing the disclosure statement for the pre-sale property. Once that's prepared and filed with what's the organization name? BCFSA? Yeah, it's changed a few times since I've come into practice, but it's the BC Financial Services branch that we have to file a disclosure statement with. So once that's filed, developers need to file a amendment to this document, setting out when they've obtained a lender's promise basically to provide construction financing for the property. So basically construction financing is money to help build the property while it's in a pre-sale form. And then the developer can enter into pre-sale contracts with potential purchasers. And so our firm collects the deposits paid by the purchasers and keeps track of all the contracts entered into. And then once the property is complete, we help to facilitate all of the sales of these units. So depending on the property, this can be a huge undertaking. It can be hundreds of units. So for our firm, that kind of means all hands on deck. So all the real estate lawyers they're very late at the firm to deal with like this huge amount of closings. But this is the exception, not the not the rule for closings. And then after some of the units are sold, your developer client may obtain inventory financing. So this is financing that a developer gets for unsold units in a development to help them pay for, I assume, it's costs of maintaining these units.
Yeah, and sometimes just to take effectively equity out in their projects. So if they've got units that they haven't been able to sell, or they've got a commercial component that they want to retain, they may want to take cash out of the project, and that's why you'll obtain this kind of post-closing financing.
Yeah, so I was just gonna say it's kind of cool to see like the life of a development. Like you go from nothing in the ground to like seeing it built and like seeing them enter into contracts and then finally selling all of the units. So it's nice to see progress in that sort of sense on these types of files.
Yeah, sorry, we'll just go back for a second. I think one of the things to keep in mind is also the timelines you're working with and the scale and the scope of the services you're providing. I'd say kind of a development file could run you 6-7 years, depending on how long, how early in the process you're involved. A lot of times you get brought in, if you've worked with a client for a number of years, they'll bring you in early and say, we're looking at this site. There's a couple of properties, or there's this one large site. We want to buy it. And we've got this vision of a 300 unit residential complex plus an office building. We're going to do this incredible work here. And you're like, okay, let's start talking through it. And then they'll realize, well, wait a second, this project's huge. We probably need a partner in on this. And so you might be brought in to help with the acquisition of the property. And concurrently, you're then going to work with them to create some partnership or other joint venture agreements. You might create a limited partnership where you have your client, plus there'll be another law firm acting for their partner. So a lot of times institutional funds or large equity groups will come together and say, we're going to put money in this project. Let's negotiate these large, complex joint venture agreements. And then you complete the acquisition, you get some bank financing, so you're not out of pocket for the entire amount. And then you work with them through rezoning. So you're dealing with the city. Now you've got to get rezoning. So right now there might just be permitted 10 stories of residential and nothing else. You rezone it to permit 30 stories of residential plus an office building. You carry that process through, you get rezoning, you get entitlement, you have to work with the city on settling all the legal agreements. Then you file your disclosure statement. Now they're going to start marketing their project. You get construction financing now, because now a bank's going to come in or other lenders are going to come together and give your client the access to a substantial amount of money, which will be paid out in progress draws. So every month, the bank will reimburse your client a portion of what they've spent on the project. So as the project completes, the bank or the lender is giving more and more money. You finish that, you do the sales, the bulk sales, which is an exciting time in a law firm's life because you'll have a lot of people working to do as many sales as you can. And now they've got an office building you're going to help lease. And that might have been pre-leased. It might be something you do subsequently. 6-7 years later, you're starting to see the end of it. And the client group may retain ownership of parts of the project. So they might sell everything. So now you're going to help them on bigger sales. And that's why a project that you get in now may not seem like a big deal in the short term in terms of revenue, but over a 6-7 year period can become quite substantial. And I'm reluctant to just say it's all about the billings on this, but you get a project like this and that can really help give you some certainty of how much work you've got in the pipeline. Having a few of these projects and ensuring they're not at the same time is really important to knowing that you can sign on a lease renewal for your office space because you know you're going to have the projects that are coming in to keep you busy. And it makes sure that your planning for your team is quite important because now you know you'll need a team to help you get through this process. So one client, one project could be 6, 7 years of work. Conversely, a residential conveyance could be 2 weeks and you never hear from them again. So it's a stark contrast. But this is certainly more exciting, in my opinion, to be involved with something from the get-go. Oh, that's good. 2 questions.
I was just wondering, while you're working on a development file, does your work overlap or do you work alongside many construction lawyers?
Yes, so when you say construction lawyers, in my mind, there's kind of the solicitor side, which is negotiating your CCDC contracts, your construction contracts, your general contractor or your subcontractors. There's that type of work. And then the other side is the litigators, so our construction litigators who get involved when there's disputes, when someone claims they haven't been paid or thinks should be paid more, or there's a claim because something has happened that's changed the pricing. Um, I do try my best to stay in my lane, and so I don't typically advise. So if a lien gets filed on title to the property because someone claimed they should have been paid and they haven't been paid, I just hand that right over to one of our litigators and say, it's all yours. Like, have fun with it. And Jen and I get to sit back and watch them work their magic. So, yes.
I also wanted to ask if you could kind of like speak to your past 2L self. Would you have any courses apart from like real estate transactions that you would have wish that you'd taken or that you recommend that somebody in law school take? You guys have mentioned securities like 6 times already. Anything else? I don't know.
I hardly took any real estate courses at all, and now it's all I do. I had a very strong interest in Indigenous and Aboriginal law in law school, and so that kind of tied back into my interest in land. So I took a lot of those types of courses. I do think securities is useful, although I never practiced it, to get a sense of like the business considerations that kind of go into a real estate practice. But I would just say study what you're interested in. I do think litigation is probably not as relevant, but it's always nice to have a background of the considerations that could give rise to litigation claims.
Yeah, I'd just say broaden your horizons. Don't marry an area of law in law school. I think that it's important to get exposure to different areas. I took property law like 1L because I think you have to, and then I didn't take another real estate course, and I thought I was going to be a litigator, and so I took some, like the oral advocacy class, and I really thought that's what it was going to be. I think it's important. You get some very important foundational skills in law school. I think you learn some really important skills that you can get from a number of classes in law school. But I think PLTC was actually where I really learned a lot of practical, how my files work, information, or that's where I got it. And then just practice itself, getting the experience of deal flow. So it's probably not the answer your professors are going to want to hear, or like I'm sure others have other opinions, but if you ask, my opinion is, I took sports law in 3L because I thought, hey, great, I want to be a sports agent. That sounds great. And like, there was I don't think there's any real value to my career that I took sports law other than the fact that it kept me engaged in third year, right? Like in third year, I was like, I don't know what I want to do. I guess I'm going to do private practice. And I took it, and it was great because I cared about the material and I was interested in it. And I think that's really important part of your selection of courses.
Yeah, so this is our final slide actually. Besides the partner perspective, of course, this is my final slide. So just giving you guys a couple of reflections about my real estate practice. Real estate is a very broad practice. Like we've run through like the key areas here, like which is transactional purchase sales, leasing, lending, and development. But there's a lot of technical knowledge that goes into a real estate practice that unfortunately, well, I at least didn't learn in law school. I went to school in Ontario, dealing with the land title office, there's a lot of like very finicky considerations that can determine whether your application is going to be bounced or not. But I think it's important to gain broad exposure to a variety of areas early in your career so you get a sense of what you like and what you don't like. And then as you get, I was going to say get older, you gain more experience in your practice area. You can really drill down and gain expertise in specific areas. And that's when you start to recognize what you know and what you don't know, calling back to our previous slide. One thing that's always been relevant throughout my practice, I was called in early 2020. I'm a fifth year call now. They count the year that you were called in. And that was, there was a lot of COVID developments. And so that was my initiation into the practice, learning to deal with all of the remote witnessing requirements that the land title office developed on the fly because everyone was locked down due to COVID. So there's always new developments in real estate. Like, I think there's a perception sometimes that a solicitor practice is boring because there's no changes in the law, but that's definitely not true. It's actually a very dynamic area from my perspective, and there's a lot to learn both from people who have knowledge of historical kind of files to those who have a better understanding of how the law works, and also to new developments that can come up due to new case law, new legislation being put in place. There's new taxes every year that we need to learn how to deal with and what the tax liabilities are and how they can follow people or property. And new types of due diligence that we need to be aware of and be conducting to protect our clients.
Yeah, from the partner perspective, it's interesting that some of the skills that I think make you a successful associate are no longer as utilized when you're on the partner side. So if you're really good at drafting, and it's unfortunate, you end up getting stretched to doing other things as well. And so it's an interesting twist. There's, I think, a moment where you become an article student or a summer student and you realize, oh, the skills that made me, this like a really good student aren't necessarily translating super well. And the skills that make you a really good articling student don't necessarily translate to being a really good first year associate. And it kind of continues on, you picking up new skills. One of the important parts of the partner perspective is your client relationship and management. You're often going to be, especially as you get more senior, you have your own practice, you're going to be responsible for managing a number of very quirky people who retain you and want to have you provide services. So you'll need to understand how to manage people. I think that's a skill that doesn't get focused on enough, and it's an important part of your ability to grow and develop. So you think of yourself as if you were to silo yourself and say, what are the skills I can bring if I want to have a transferable practice, or I want to be able to say, hey, I deserve to be compensated differently because I'm really important. It's having good clients. It's having the ability to manage your clients, having the ability to manage other clients if they come to you, and growing that practice. So it's an important part of your job as a partner. The file and team management, again, you're going to have files that sometimes you can work on by yourself, but a lot of times you're going to need a team. You're going to need somebody who you can trust, or you need a team of people you can trust, paralegals, associates, other partners. And it's about managing everyone, because amazingly, even at that level, sometimes you say, we really need to get this out to the client by Tuesday at 5 p.m., nothing's there. How do you manage that? Now you got to go manage your client. You got to keep your people engaged. You got to make sure, there's things that come up in life that are outside of the practice, and that may be something you need to be aware of. So you're not pushing people at the wrong time. You need to be able to support your team and create an environment where everyone can work together and wants to work together. Dealing with issues, a lot of time you spend is sometimes mistakes happen. And I say mistakes is not the reportable to your insurer mistakes, but mistakes like the client expected something and it didn't happen, and the client feels let down, or they feel like, hey, this isn't what we're paying big bucks for. How do you manage that? So how do you handle those tough phone calls? How do you handle internal disputes? If there's disputes amongst colleagues, how do you manage that? And a lot of times you have to take ownership of it, and you got to make sure you've created an environment that can help resolve those issues. The part that they definitely didn't teach me about in law school was people don't actually pay lawyers when they're told to pay. This is the crazy part. You get called from a client, say, I need you to spend 10 hours doing this. You do. Then you send them a bill for the 10 hours you did. They told you could spend 10 hours, and then they just don't pay. It is incredible to me that people just don't pay. And what do you do then? Then you wait 30 days and they still haven't paid. And then you get, then you wait another 30 days and all of a sudden someone calls you and says, Aneez, your receivables are up. And you say, what are you talking about? They say, well, you've been doing all this work. You're the greatest shoe salesman in the world because you're giving shoes to everyone and not collecting any money. It doesn't work that way. Your practice is based on not just billing, but on collecting the money from your clients. So as much fun as it is to say, oh, we got to deal with issues and legal issues all the time, part of my day is also talking to my clients and saying, what's going on here? Why aren't you paying? And sometimes understanding that in real estate, they are cash poor. They might be worth tens or hundreds of millions of dollars, but cash is king for them. And they'd much rather spend the money on the tradespeople who are going to help them finish their project. So sometimes you got to pick your spots and you got to tell them, this is how we'll work. We'll give you 60 days to pay. And that might be the cycle that you have to accept. Or sometimes you have to say, these guys are in trouble and I might have to let them finish the project and then scoop all of my fees. And now you're effectively their bank. And that's something you're going to have to make sure you and your partners are okay with, because law firms aren't banks and you're not in the business of giving out credit, but it turns out you actually are. And so that's something to keep in mind, billing and collecting. And don't get me started on the clients who say, yeah, you can, I really want you to do a good job. Make sure it's done tomorrow. I need this, I need this, I need this. I can't believe how much you're charging me for this. And you say, well, wait a second. You wanted a team of lawyers to work on this, drop all their other files, and now you're going to grind me on fees for this? You want a 5% discount? You want a 10% discount? You're not going to pay me? So it's managing all of that. Again, it's something you just have to, you learn through experience, you learn when you manage clients. And unfortunately, the reality is sometimes you just decide that this is just not a client I'm willing to work with anymore. And so it's a constant struggle of finding the right balance. Most clients who aren't institutional, they don't have a system of paying their bills every so many days. These are things that are going to come up from time to time. Sometimes it's, oh, I missed your bill. I just misplaced it, and they'll pay right away. Or sometimes it's, they just don't answer your call until they need you again. And then all of a sudden, oh yeah, that bill from 6 months ago, it wasn't that much work, right? It was 6 months ago. No one really remembers, and they'll offer you less than the full rate. And you say, well, maybe I shouldn't be doing this type of work anymore. Maybe this isn't fair to my colleagues who have worked so hard on the file as well. So, and then you contrast all that with, but you also really want the next deal, because that's how you eat in this game. And so you've got to make sure that you're not firing every client if they don't pay the day after they get their bill. You got to make sure you've got a good rhythm. And sometimes your good clients get a bit more leeway. And sometimes your average clients get a lot of leeway. But that's something you have to track and something that you'll manage as you get your own practice and you start building your own practice and what you're comfortable with. So that's the partner perspective. I will add one thing that we didn't put on the slide, but the dream scenario, which I like to think I'm in right now, is you also find yourself a gen, and then your practice will run a lot smoother than it was before the pre-gen era. So it's really nice to have somebody who your clients can call directly, who can do the work and can also acknowledge when there's areas they may just not have the background on. There's a file that came in that the client went right to Jen, didn't bother to copy me. Apparently they're Jen's client now, not mine. And they do like her a lot more than me, I can tell. But she knew that like 8 years ago, I'd worked on something on this project and I had some background. So she came to me and said, oh, the client came to me, asked me for this, but it seems like there was some history here. Can you give me the background? And that's the perfect situation, because now the work's going to the right person, the client's happy. And internally, we're giving the client the best service because they're not going to miss out on any institutional knowledge that we have. So if you can get yourself a Jen as a partner, hands off, but also she'll be much past me in that. But when you're in my position, she'll be, I guess, senior to all of us. And that really does make your partnership, your practice as a partner, a lot more successful.
Thank you for the kind words. And that's it. Thanks everyone for coming.